Good morning to all of you. Welcome to Legal Matters by Babu Sunkara. In this video, we are going to discuss the importance of Order 23, compromise of the suits in CPC. Particularly, we are going to deal with Rule 3A, Order number 23, that is withdrawal and adjustment of suits. You all know, at any stage of the suit, you can withdraw the case. At any stage, you can adjust the suit, that is satisfaction memo or satisfaction decree, consent decree, all the things you know very well. But here the important point is whether an appeal lies on a compromise suit. Please remember, after compromising of the suit, whether an appeal lies. Yes, the reply is no. But the party which is not connected, yes, they have got the right to file a set-aside petition. The parties involved, they can't go for appeal because it's a compromise. The parties who are new, yes, they can. That is what is stated by the Jammu and Kashmir High Court in the case of Nikhat Nabi, Nikhat Nabi versus Messrs. Fancy Fabrics and others, which are having loan with Jammu and Kashmir Bank Limited. So this relates to CM number, CM within bracket M, 265 by 2022, decided by Honorable Justice Javed Iqbal Wani on 22/9/2023. Now, if you go to the facts of the case, Messrs. The so-called Fabric and others, here they are Messrs. Fancy Fabrics and others, right? They are located in Srinagar, right? So, they have done their business to some extent well, but they fell in dues. That particularly cloth business is such a business where you bring the material in advance, you sell them and pay back the money. This is what we have seen in Chirala. People used to go to Gujarat, particularly Surat, then Bombay and Bhiwandi or some other places. There are certain agents to them. They used to collect the cloth. After selling the same, they used to send back the money. That is the routine procedure in any cloth business. Likewise, they have taken loans from so many people. Particularly, the company took loan from J&K Bank and they have become defaulters, right? So, the J&K Bank, they have instituted a civil suit against the so-called Messrs. Fancy Fabrics and got a decree, right? Then they came for execution. At the time, there were discussions or deliberations between Fancy Fabrics and J&K Bank. Ultimately, they agreed for a compromise. Of course, that is also not acted upon by the Fancy Fabrics. Later, on some other day, they have agreed upon. So when they compromised, they have gone for Order 23, Rule 3, that is compromise of the suit. So Order 23, Rule 3 says, where it is proved to the satisfaction of the court, this is more important, that a suit has been adjusted wholly or in part by any lawful agreement or compromise in writing, then the court shall order that as satisfaction and the case will be finalized. And Rule 3A, more important, please remember, Rule 3A, bar to suit. So, no suit shall lie to set aside a decree on the compromise suit. That means the parties, they can't go for appeal or they can't go for setting aside. But here the point is, now the real fact comes to light. The present Nikhat, so they stated that they have provided a loan of 3 lakhs. They have provided a loan of 3 lakhs to the Messrs. Fancy Fabrics in the month of February 2002 at the rate of 3% interest, and the respondents have given undertaking. They have executed a promissory note as well as a declaration that in case they fail to repay the money, the shop will come under the charge of this petitioner or appellant. But they did not. The bank did not know it, and Messrs. Fancy Frank did not inform these people, and they have taken the compromise decree. Having come to know the compromise decree, this man filed a petition before the court. Of course, he has filed a petition under Article 227 before the Honorable High Court of Jammu and Kashmir to set aside the orders given by the lower court. Of course, that the first time lower court did not agree. Right here, this is the point. But the thing is, this declaration is not registered. No doubt, promissory note is there. Now the court said, you can't go for setting aside the order because it's a compromise suit between the parties. No doubt, you are a third party. What you have to do? You have to file a fresh suit. Please remember, you have to file a fresh suit, then the matter will come up. Of course, the attachment is there. They can get the property attached to some extent if it is not done so far. But the important legal point is, definitely you can file a petition if you are not a party. Right? So, the crux of the case, so if I am going on telling you the facts of the case, you may be confused. With this, let us stop. The important point is, yes, the third party should have filed a fresh suit. Then he should have asked for the restoration or setting aside the decree. Without filing a fresh petition against Messrs. Fancy Fabrics, you cannot come and file the set aside petition. No doubt, you are a third party, but still you have got to institute a civil suit first and then come. Straight away, the jurisdiction of the Honorable High Court under 227 article is not accepted. Right. The important legal point is, yes, the compromise suit cannot be appealed or cannot be set aside, but the third party can ask it to be set aside. Right. With this, I am concluding. Thank you very much.